FERPA, the Federal Educational Rights and Privacy Act, is federal law that protects the right of students to control the information in their educational records, to control who sees it, to control who it's released to. That law basically affords students the right to inspect their own educational records and the right to consent to the release of their educational records unless release is specifically addressed by exception. So what does that mean for us at a community college? It means that basically any student, regardless of their age, has the right to control the release of their own educational records. It means that you, as an instructor, as a tutor, as a staff member, have to be aware that the student has the right to control their educational records and who that information is released to. That can also affect your discussing educational record information with a student when they're right in front of you with a group of friends. Not always the best thing to do. You may want to ask a student to step aside. So what are educational records? Educational records include academic records, grades, test scores, attendance records, advising records that are in shared files, like a counseling file that more than one counselor is liable to pull and look at, instructor records or notes in any media that may be shared with others, emails, letters that contain personally identifiable information, student disciplinary records, any disability records. Now, aggregate data that includes personally identifiable student information, research results that specifically identify students are also considered educational records. Research results, aggregate data that does not specifically identify students are not considered educational records. Any other written document, formal or informal, that contains personally identifiable information about a student and is shared with another individual or individuals becomes an educational record. The following are not considered educational records. Notes are other records that are created by and remain in the possession of a sole possessor, basically the creator of the record. Law enforcement unit records, although there are exceptions. Employment records, medical records, for the most part, but it's a little different for community colleges, and I'll get to that in a minute, and post-attendance records. Law enforcement agency records may be considered educational records if the law enforcement agency is identified as an agent of the college or university, such as our police department here at Ventura College. Medical records at a college or university student health center are also considered educational records. Anyone who works on a college campus is basically responsible for complying with FERPA. Employees, faculty members, staff members, tutors, student workers are all acting as agents on behalf of the institution and are responsible for complying with FERPA. The campus registrar is the official custodian of educational records. The majority of information releases come through my office. When an institution doesn't comply with FERPA, it stands to lose federal funding. And even though you can't be sued in court for violating FERPA, you can be sued for violating an individual's privacy or for libel or slander. Persons that have access to educational records are primarily controlled by the student. However, the student can release their records to anyone they so choose by giving the institution permission to do so. So if a student gives you a written request for a reference letter, then you have permission to cite information in their educational record, although you do have to be careful about it. Employees of the educational institution who have a legitimate educational interest may access a student's records. Oddly enough, none of us have an inalienable right to student record information. The admissions office staff, financial aid office staff, counselors, none of us have a right to that information. What we have is a legitimate educational interest as a reason for accessing it. Individuals and agencies who are identified in the annual disclosure notice, which is in the catalog, as agents acting on behalf of the college, providing they have a legitimate educational interest. That phrase keeps coming up. Institutions are required by law to release educational records under certain conditions, such as the presence of a lawfully issued subpoena or court order mandated reporting to a state and/or federal educational agency. You have to understand that the way information is delivered makes absolutely no difference. FERPA still applies, whether you are talking to an individual face-to-face, whether you are mailing, emailing, tweeting, Facebooking, doesn't matter. The regulations apply to distance learning situations, online discussion groups, email communications, website postings. Any information that's posted must not include educational records that are directly related to a student and must not contain personally identifiable information in such a way that it would violate FERPA. There are some basic guidelines for complying with FERPA. And the first one is this: when in doubt, don't. If you have a question in your mind whether or not to release information, whether or not to discuss something with a student, whether or not to pass something to someone else, contact the registrar's office for guidance. I will do my best to give you a direct answer, although FERPA can get a little complex sometimes. Consider everyone other than the student a third party. That means that the student's parents and friends are third parties. If a student approaches you in public to discuss a grade, a test score, anything you may be dealing with the student about, try to move the conversation to a private venue. Do not post grades, test scores, any information about a student publicly, even if you're only using a partial name or partial ID number. They can be connected by someone who wants to play that particular type of game. The information is still considered personally identifiable. Don't send grades or any educational information, educational record information, by postcard, fax, or email. They do not guarantee confidentiality and may be considered a violation of FERPA. Get the student's written request for letters of recommendation. And this is something that isn't often thought of, but it's a wise thing to do. Usually you're only going to say the best about a student if you're asked to give a letter of recommendation or a reference. But the reality is even your best may not produce the results the student thinks it will. And in those cases, you may have an unhappy student on your hands. It's best to cover all the bases, get a written request. If you're contacted by investigators or legal authorities seeking information about students, please refer them to the registrar's office. Their identity has to be verified, the purpose for their request for the information has to be verified, and in most cases, a written release from the student is still required. And remember that a student cannot be required or coerced into providing written permission for the release of her educational records. That means mom and dad. Never discuss grades, academic performance, or other non-directory information over the phone. Refer callers to the registrar's office. You never know who you're talking to in a phone call. No matter how many identifying questions you ask, a parent is going to know just about anything. Best not to discuss it over the phone. If a caller is claiming an emergency situation, refer them to the registrar's office or to campus police. School officials, any school official, must have a legitimate educational interest to obtain student records. And by school officials, I mean all of us. I mean staff, faculty, administrators. It is not considered legitimate educational interest for faculty to review previous academic work in other classes prior to awarding a grade, nor would it be appropriate for tutors or assistants to review that type of information in a student's educational record. Let me revisit the first guideline rule because it's the best. When in doubt, don't. If you are not sure, absolutely sure that you can discuss something with a student or with someone else about a student, please don't. Contact the registrar's office and we'll figure it out. Thank you.